Right, good afternoon, everyone. The court has convened to hear criminal appeal number 7 of 2021, which is the Queen against Dwayne Creary. Mr. Alan Richards of the DPP's office appears on behalf of the appellant, and Mr. Mark Daniels appears on behalf of the respondent. These proceedings are taken before the President, Sir Christopher Clark, and Justices of Appeal, Dame Elizabeth Gloucester and Mr. Justice Jeffrey Bell. My Lord President.
I'm sorry that you have been delayed. It was, as you will have seen, because the case before us was significantly delayed, but we're here now, so we can start, if we may.
Yes, my lord, and I think we will be significantly shorter than the matter that has detained your lordships and your ladyship.
If you're not, there will be something seriously wrong.
Indeed. So, my lord, this is actually a second appeal, as I'm sure that the court appreciates from having studied the record and the other paperwork that has been filed. Mr. Creary was initially tried in the Magistrate's Court on 2 charges of causing GBH by careless driving. He was convicted by the magistrate. There was no appeal against his conviction. He was sentenced by the magistrate to fines of $2,500 on each of the 2 counts in the information and consecutive periods of disqualification of 2.5 years on each of the 2 counts in the information. He then appealed against sentence to the Supreme Court, and there is, with respect to the Supreme Court, some confusion as to precisely what it did, because there is a difference between what it said in the transcript of the proceedings, and here I'm speaking specifically of page 68 of the transcript, page 277 of the record of appeal in this court, where it appears that the learned puny judge intended to substitute a fine of $3,000 total for the $5,000 total that was imposed by the learned magistrate. And her written ruling, which appears at the next section of the record of appeal, tab 30 in the version that I have, where in the concluding paragraph, which is on page, not the concluding paragraph, the penultimate paragraph, which is on page 286 of the record of appeal, the learned justice says that she saw no reason, nor was she invited to interfere with the $3,000 fine. Well, as your lordships will have detected from what I've just said, it wasn't a $3,000 fine, it was a $5,000 fine. And in fact, that is correctly stated at the start of her ladyship's judgment. So obviously that's simply an error. And insofar as the Crown can understand what her ladyship intended, it appears that she intended to substitute a total $3,000 fine for the total $5,000 fine that the magistrate had imposed, albeit
3,000 being the maximum.
3,000 being the maximum on conviction for one offence, which is a point that I suspect we will have to spend a bit more time on shortly. But if I can just try to dispose of the matters which don't need to trouble the court first.
She said that she didn't see any reason to interfere with the 3,000 fine, and it was in fact 5,000. But you gave us an earlier reference, which I didn't quite pick up, where she seems to have said something else.
Yes, so that was in the transcript of the hearing before the learned justice. Now, I have to confess, when I wrote my written submissions, I didn't have the benefit of this transcript. Right. But if you look at page 68 of the transcript, which is page 277 of the record, there's a section between lines 12 and 20.
Could you hold on a sec, Mr. Richards, because I did not have this printed out, so I'm going from the cloud. It's going to take me a little time. What page of the record?
277, my lord.
277. And it's taking its time loading. Well, why don't I just make a note and have you read it.
Yes, my lord. So there was some discussion about whether or not she was going to issue written reasons. And she said, that I'll read the whole of this particular utterance. I mean, they're likely to be short, but I think it's certainly my consistent approach to this. Then there was something the transcript writer couldn't get. In any event, but I will go ahead and I'm going to allow the appeal to the extent, as I've just outlined, that the period of disqualification shall now be for the period of 2 years, and the fine shall be reduced from the total of $5,000 to $3,000. And I'm going to follow that up with written reasons.
Right.
That's what she did, wasn't it?
No.
Yes, she did follow it up with written reasons, but they didn't precisely encapsulate what she had said.
Well, the result was 3,000.
No.
Well,
what she said in the judgment was, I see no reason, nor was I invited to interfere with the $3,000 fine.
Oh, I see. Yes, yes. Yeah, I follow
precisely.
that.
So I think that the only sensible construction that can be put on the combined effect of both what she said in the hearing and what she wrote was that she intended to reduce a $5,000 total fine to a $3,000 total fine. But with respect, the written reasons don't quite state that by themselves.
It's not a question of the written reasons not stating that. She didn't do it in terms of the judgment that she signed off on.
Well, I can't argue with that, my lord.
But 3,000 was the maximum that she could give
Yes.
anyway. She was only having one count.
Yes, that's true, my lord.
No.
But of course, there wasn't an appeal against conviction before her.
No.
There was an appeal against sentence. The appellant before your lordships, and I'm a little wary of using those labels because, of course, we have switched roles. But
Yeah.
the Crown has filed notice of appeal on the basis that the learned judge is effectively overruled one of the two convictions as well as altering the sentence. So we've appealed on both bases. And the real substance of this appeal, as your lordships will be aware, is whether the learned justice was right to conclude as she did in paragraph 21 of her written judgment, which is the top of page 286 of the record of appeal. But I without wishing to detain the court without profit, I do want to just park some of the issues that I think that, subject to the court's views, do not need to detain us any further. I accept, and just so that your lordships know, for the
Actually,
purpose.
could you just hold up 1 second, Mr. Richards? I'm just completing my note on your previous comment. So, and right, thank you.
Thank you, Lord. So just so that your lordships understand the sequence of alternating appearances for the Crown in this matter, I did not prosecute the trial. My learned friend, Mr. Rogers, who may be on the call when he's able to, prosecuted the trial. As it happens, he was not available for the sentencing hearing before the magistrate. So I actually appeared at that hearing. Mr. Rogers then took back conduct of the matter for the purposes of the appeal before the Supreme Court. And now we have once again alternated roles, and it is me before your lordships and your ladyship today.
Yeah.
So I have to accept responsibility because it was me that appeared for what was said by the Crown at the sentencing hearing in the magistrate's court. And I have to accept, upon reflection, that what I asked the learned magistrate to do, at least in terms of the disqualification, was not lawful, because I was under the mistaken impression that he had some discretion to exceed a 2-year period of disqualification. And as I think is now common to the parties and clear from the judgment of the Supreme Court, that there is a somewhat strange position whereby GBH by careless driving, which is an either way offence, can be tried in the Magistrates Court or the Supreme Court. When it is sentenced in the Magistrates Court, the magistrate only has the power to impose a mandatory disqualification of 2 years. He does not have the discretion to impose a longer period of disqualification.
Longer or shorter?
Longer or shorter, well, subject, of course, to special reasons, my lord, but that's not something which I think we need to concern ourselves with for the purposes of this case. The subject to the general power of the court to find special reasons, either not to disqualify or to disqualify for a shorter period. Essentially, there is no discretion in the Magistrates Court. It's a mandatory 2-year period on conviction for an offence of GBH by careless driving. That is different from the position in the Supreme Court, where the same offence can be tried. And without wishing to trumpet my written submissions, I find it somewhat easier to follow than the actual act. The Traffic Offences Penalties Act has a very long schedule, which is quite laborious to navigate. And if you look in the second set of submissions that I've filed, my lord, those dated the 5th of November this year. In paragraph 4, I do set out a table.
I don't seem to have that. Where are we?
Well, in the cloud, my lord, they're in the submissions folder. There's one set dated the 25th of October, which was my original submissions uploaded by Mr. Coelho. And then there's another set uploaded by a guest contributor, and that was me.
Well, I'm afraid I must announce I wasn't aware that you had filed further submissions on November the 5th. I see now that they are on the cloud. When I have clicked on the cloud, it has done its usual technique of blanking out.
Sorry to hear that, my lord. Not quite sure what to suggest.
No, I don't. It does it all the time. It's a complete nightmare.
So, and I'm having a problem getting, so submissions of, right, guest contributor, let me see if I can get them. Yes.
I've got it.
Right. So I don't know what we do about my Lord President,
If my Lord President can't retrieve them, I can share them as before.
Well, yes, okay, just a moment. That would help.
What is the paragraph reference, Mr. Richards?
Or
Right.
right, so my lords, my lady, I don't propose to take you to the Traffic Offences Penalties Act, but if you have a look at it, should you so wish to, you'll see that there's a very long schedule there that sets out the penalties for all manner of road traffic offences. And in particular, it prescribes different maximums for first, second, and third offences.
Yeah.
This table summarizes the maximums only for a first offence of GBH by careless driving. So, and it also summarizes the maximums for careless driving and death by careless driving for comparison purposes. So if we take the middle row of the table, bottom of that page, you'll see that whereas there is a 2-year obligatory, and obligatory is the statutory language, I often seem to say mandatory instead, but same thing, I suppose. So 2 years is the obligatory disqualification in the Magistrates Court on conviction for GBH by careless driving. If you
what's the reference to 3 years in the first column?
That's the maximum period of imprisonment.
Right.
So the penalty, to read across the whole row then for completeness sake, perhaps meaning that we won't have to come back to it, the maximum penalty in the Magistrates Court for a first offence of GBH by careless driving is $3,000 or 3 years imprisonment or both. The maximum, the number of points, which is largely irrelevant because unless the court finds special reasons, it won't have to record points separately from the disqualification. The points range is 8 to 10. but as I say, there is an obligatory 2-year disqualification. Then we move to the Supreme Court, where the same offence can be tried on indictment. There, the maximum.
Isn't it?
I don't concede that it is academic, my lord. No.
Why is it helpful for us to look at?
Because I think, my lord, that what the maximum penalty is for the offence is relevant to the appellant's contention that he should not, by combination of penalties, have been punished in a way that exceeded the maximum power of fine in the magistrate's court.
But the case is going to turn on whether it was right for him to be charged with 2 counts, which meant that because the magistrate ordered the sentences to be consecutive, he got 2 + 2.
Well, I
mean,
respectfully, my lord.
Isn't that the start and finish of the case?
No, I don't believe that it is. I first of all, respectfully, I don't think that the words consecutive and concurrent are particularly helpful to us in the context of fines, because fines can't be consecutive or concurrent.
No, but I'm thinking of the disqualification.
Oh yes, and let us not forget, of course, I am trying for apologies for the pun, but I am trying to park a couple of issues, and that is one of them, because we are not now, I think, really disputing the issue so far as the disqualification is concerned. But what I was hoping to do was to go through the entire of this row of the table now, so that the maximum, so that we have established for the purposes of this hearing what the relevant maxima are, and we don't necessarily have to come back.
I still don't really understand why it's relevant for us to look at the 3 years that could have been imposed in the Supreme Court when he was in fact tried and dealt with in the Magistrate's Court, where, as you've told us, the 2 years disqualification was a mandatory period, absent special reasons.
Yes, and the only point that I was seeking to draw out of this at this stage was that you can distinguish the position in the Magistrate's Court from the position in the Supreme Court, where in fact there is a discretion to exceed the mandatory period of disqualification. So in the Supreme Court, the mandatory period of disqualification, or the obligatory period, is, as you can see from this table, 3 years, and there is a discretion to go up to 4 years. So I was thinking...
I'm very puzzled, but I thought you conceded that you couldn't have consecutive disqualifications.
Yes, I just haven't quite managed to get there yet in my oral
No, I
submission.
know. I thought we might get there quite soon.
Yes, well, there are 2 problems with the disqualification that was imposed in the Magistrate's Court, neither of which, in my respectful submission, relate to the question of whether it was right or wrong to have 2 separate counts on the information. So to the extent that the Supreme Court substituted a shorter period of disqualification for that reason, I say the Supreme Court made an error.
Well,
however, I have to concede.
The Supreme Court, well, perhaps I should just let you develop it, but the Supreme Court said that there was no discretion as to the period of disqualification, but since there was only one offence, it could only be applied once.
Yes, and that is not correct in my respectful submission.
No,
so I am going to concede, and I do concede in my written submissions, that in the result, the period of disqualification has to be a fixed period of 2 years. But the reason why that is so is not the reason the Supreme Court stated in my respectful submission.
Right.
So first of all, the magistrate did not have, and I have to accept that I led him into error in this regard, he did not have the discretion to impose any individual period of disqualification in excess of 2 years, because the statute gives him only an obligatory 2 years. The next question is whether, if he had imposed 2 years on each of the 2 charges that were before him, could he have ordered them to run consecutively? And the position that I now take, respectfully, having had a little bit more time to reflect upon the matter, is, as stated in the written submissions that we have filed, that this is governed by Section 6 of the Traffic Offences Penalties Act.
And we find that where I'm
And
sorry,
that is-
I'm sorry, Mr. Richards, that I had not read these because I hadn't realised that further submissions had been put in. So,
well, I entirely understand, my lord, but in fact that point is addressed in the first set of submissions, I believe.
It is.
Mr. Richards, are you finished with the submissions that are on the screen?
I think so for now, Mr. Coelho. Yes, I don't promise not to come back to them, but I think we can take them down for now.
so where do we find this in your original submissions?
Paragraph
So-
13.
Yes. It is touched upon in paragraph 13. Your lordship is quite right. That's the position in respect of the obligatory period of disqualification, which I think I've made. So if I can ask your lordships to move forward through the submissions, I would.
That deals with the 2.5 as opposed to 2. It doesn't deal with the consecutive aspect of it.
No, exactly. That's why I want to now move, if we can, to ground 3 in the document. So paragraph 21 onwards. It's my submission that, as I have said, reducing the period of disqualification on the basis that there should have been only one offence was incorrect. It's then explained that at first instance, it was the Crown's position that 3 years, and in fact, what I intended was 3 years total, was appropriate, but that wasn't something that the magistrate could lawfully do because he didn't have the discretion, as we have established. Then I make the point, this is halfway now through paragraph 22, that as the Supreme Court recognised in paragraph 24 of its ruling, that is on page 286 of the record, absent special reasons, the magistrate was bound to fix the disqualification period at the obligatory 2 years. What is less clear in my respectful submission is whether, given that each offence attracts a disqualification of 2 years, the court had any power to order them to run consecutively. The Traffic Offences Penalties Act is not explicit about that, in my respectful submission, but there is some guidance to be found. By comparison with the penalty point regime, the court will note, and this is set out specifically in section 4C of the Act, but I don't think that I need to ask your lordships and your ladyship to turn to it at the moment. The general rule as regards penalty points arising from multiple offences committed on the same occasion is that the total number of points to be recorded for all of the offences is the highest of the numbers available. However, subsection 4 of that section, section 4 capital C, does expressly give the court the power to award the penalty points separately if it considers that it's appropriate to do so. So as regards penalty points, the Act is explicit that they can be, that they are generally to be awarded in an overlapping fashion, if I can so term it, but they can be awarded cumulatively. So that's some guidance in my respectful submission. Another point that I would submit assists in the interpretation of this issue is that section 57 of the Criminal Code confers an express power on the criminal courts to order that periods of imprisonment may be served consecutively.
Well, you say must be, but it's a discretion with the sentencer to order consecutive or concurrent.
Did I say must? I certainly don't contend that periods of imprisonment must be ordered consecutively. I'm sorry if I misspoke. I'm saying
No, I didn't
there
know
is.
you did say that.
Okay.
No,
Well,
that's what I see in 24, isn't it?
Well, you said
it gives the criminal court the power to order that the sentences
Right.
must be served consecutively.
Should
Not,
be,
it doesn't require them to order
Right.
that they should be so served. No.
Yeah.
So the point I'm simply seeking to establish here is that both in respect of penalty points and in respect of sentence of imprisonment, the legislation, different bits of legislation I accept, but the legislation has expressly established the power to order these things to run one after the other. There is no such provision in respect of disqualifications, and indeed all that Section 6 of the TOPA, Traffic Offences Penalty Act, provides, as summarised in paragraph 25, is that where a person is disqualified by an order of the court under this act, the period of disqualification shall commence on the date of conviction. So in those circumstances, in the absence of any provision that clearly entitled the magistrate to award these periods of disqualification in a cumulative manner, in my respectful submission, even if there being two charges was right and the Supreme Court got that wrong, nevertheless, the periods of disqualification have to overlap. They both have to commence on the date of conviction. And therefore, in the result, the substitution of a total period of 2 years disqualification was correct.
But Mr. Richards, I mean, it may be unnecessary to go down this particular rabbit hole, but just say that I'm driving along, I'm careless, I'm in an accident that causes someone grievous bodily harm. Because I'm upset by that, I get back in my car and am immediately involved in a second accident, which also causes grievous bodily harm. The authorities choose to prosecute both. They are prosecuted as two separate counts. That they are the same day. I'm in court. The magistrate convicts me on both and sentences me on both. Are you telling me that I'm only subject to the one period of 2 years disqualification?
That's my reading of the legislation, my lord, and it's not a reading that I particularly relish or that I think makes a great deal of sense, but I don't really see how to read it any other way. Of course, in those circumstances, we could choose, perhaps in part for that reason, to put the two counts on separate informations, or we could exercise our discretion to certify the case fit for trial on indictment and send your lordship to the Supreme Court, which would have greater powers. And the very fact that there might be an argument that you should be disqualified for longer than 2 years total in those circumstances might be a compelling reason to do that. But at the moment, I do not see respectfully how the TOPA can be read differently from how I have set out here. Now, if your lordships wish to say that doesn't make very much sense, then you'll certainly hear no complaint from me. It's not, respectfully, the only thing about this legislation that doesn't make a great deal of sense, in addition to the formatting, which is really quite cumbersome. But there it is.
Well, I must say, on a superficial reading of Section 6 of TOPA, I respectfully think that your interpretation is the correct one at this point.
Yeah.
Well, let's hope that I get a few other things right, because I want to move now
It's a criminal statute, so we would have to adopt a restrictive interpretation.
Yes.
However unsatisfactory it is.
That is the conclusion that I have felt compelled to reach. However, I might wish to reach a different one, but there it is. So I think that deals with the disqualification issue. So although I do respectfully differ from the learned Supreme Court judge in terms of the reasoning that gets us to that conclusion, I do not quarrel with her substitution of a period of 2 years total disqualification in this case.
And if Mr. Richards, we are agreed that in her reasons in relation to the fine, that the learned judge, when dealing with the appeal, intended it to be a $3,000 figure, and it therefore cannot be more. Do you say it can be more? Is there anything to argue about on that?
Yes, I do take a different position respectfully in relation to the fine, my lord.
You say that the max is 3,000, and there could be separate levels of fine for each of the counts.
Well, I don't contend that there was any reason to impose a different amount on each count, if that's what your lordship meant.
No, that's not what I meant.
Oh, I'm sorry.
No. Let me ask you, what do you think is the appropriate level of fine that should have been imposed?
Right. I believe that the learned magistrate got this right, respectfully. He imposed a fine approaching but not precisely at the maximum for each offence, the maximum fine that was available to him for each offence. And I do not concede that there was any reason in law to require him, or rather, to put it another way, any reason in law to prevent him from, by so doing, to exceed the maximum fine that was available for a single offence.
Right. So you say that 2,500 is the right number, and the magistrate was entitled, since there were two counts, to order that fine to be payable in respect of each count.
Exactly so, my lord, yes.
Yeah.
So that's the only thing we're fighting about in practical terms.
In practical terms, yes, my lord, that is so.
Though no doubt it's an important, it's important to decide whether there was one offence committed or two, because
Well,
if you are right and the learned judge hearing the appeal was wrong, if Mr. Creary had, instead of colliding with a motorcycle with two people riding on it, if he crashed into a car with 6 people inside, all of whom suffered injuries, serious or less, then it would have been appropriate for there to be 6 counts.
yes. Now, of course, I don't necessarily intend that in that hypothetical, it would necessarily have been right to find him $2,500 for each and every single one of the 6 persons. I can see an argument that, looking at the totality of the circumstances in that case, either that there should have been perhaps a period of imprisonment imposed, or that one should have discounted to some extent any financial penalty that was imposed, bearing in mind obviously that the principles of totality would be engaged there, perhaps more acutely than with respect they are engaged in this situation. Right. But in my respectful submission, that there are really 2 issues that are engaged here, now that we've got to the more controversial portion of this appeal. And I mean, obviously it's up to the court what it says about what I have said so far, but in my respectful submission, there is some utility in the court explaining why a 2-year period of disqualification was correct here, if it agrees with me, on the basis that I have advanced, rather than any other basis, because the application of this legislation is not easy. It is, road traffic legislation is often technical and sometimes convoluted. But in my respectful submission, in order to guide future practice, I would respectfully suggest that there is still some merit in the court explaining why the 2-year disqualification period was correct.
Which you say should be by an application of Section 6 of TOPA, 2 counts, but we're stuck with 1 period of disqualification, and therefore it's the 2-year figure.
Yes, you have.
As opposed to the judge's path, which was to say there's only 1 offence, and therefore there's only 1 appropriate disqualification.
Yes, my lord. Exactly so. Right. I think that therefore I can move on from the disqualification point, because it's apparent to me that the court's understood my submissions. So we can turn to the question of the fine, the question of whether or not it was appropriate for there to be 2 counts on this information. So this is a point that the court has asked the parties to consider again, because I think that, at least so far as the first part of this argument is concerned, the parties appear to be ad idem, namely that there wasn't anything wrong with the Crown alleging 2 charges on this information and the court therefore convicting of them. In my respectful submission, that is clearly appropriate for a number of reasons. The first of those is set out in paragraph 2 of my second set of submissions, the ones dated the 5th of November. I don't know whether in order to follow those, my Lord President, Mr. Quayle is going to have to put them back on the screen for you.
He has. No, I haven't got them.
You
They
have.
have disappeared from the cloud.
What paragraph, Mr. Richards?
If we could start at paragraph, well, we may as well start at paragraph 1, Mr. Quayle.
Okay.
So, my lords, my lady, the first paragraph in these submissions sets out the issue as it was summarized to the parties in Mr. Quayle's email. Because, of course, if it's stated therein that but the court is not presently convinced that such agreement is correct if it appears to be the case, and as the judge held, there is only one actus reus. Now, with respect, my lords, my lady, that language is not language that I have seen precisely replicated in the learned judge's decision. But in my respectful submission, to the extent that that may be an accurate paraphrase of what her ladyship said, there was not, as a matter of statutory construction, a single actus reus in this case. And in order to support that point, I quote in paragraph 2 the text of section 37 capital A of the Road Traffic Act 1947, which provides that any person who causes the death of or grievous bodily harm to another person by driving a vehicle on a road or other public place without due care and attention or without reasonable consideration for other persons using the road or public place commits an offence. So in my respectful submission, it's plain on the face of the statute that there is here a compound actus reus, which is not just based on conduct, but also consequences. The act of driving carelessly alone is insufficient. The actus reus of this offence is constituted by causing GBH or death to a person by driving in that manner. Therefore, in my respectful submission, a person who causes grievous bodily harm or death to more than one person by driving their vehicle in that manner has quite simply committed more than one such offence.
But the actus reus is the driving, isn't it? Not the injury.
I don't accept that proposition, my lord. I think that there are conduct crimes and there are result crimes, and in this is a hybrid. This is a case where not only the conduct of the physical conduct of the defendant, but also the consequences that it has are part and parcel of the actus reus. Or put it another way, the injuries to the complainants have to be either part of the mens rea or the actus reus. In my respectful submission, clearly they're not part of the mens rea. They are part of the actus reus. And so I don't accept that the actus reus is only the driving. If a person was injured as a result of careless driving, that is an offence. If another person was injured as a result of the same careless driving, that is, in my respectful submission, another offence. And there are good practical reasons why, in my respectful submission, that is the appropriate way to treat them. Now, it may well be that in this particular case, there was no great dispute that the injuries to these two persons both amounted, or each amounted, more precisely, to grievous bodily harm. But that is not always going to be the case. It may well be that one incident results in one incident of careless driving results in the death of one person and grievous bodily harm to another. In my respectful submission, clearly in those circumstances, it would be appropriate to charge 2 counts, one of causing death to the person who died by careless driving, one of causing GBH to the person who was so injured.
Give me a moment, Mr. Richard. I just want to catch up on my notes if I could.
Of course.
Right, thank you.
And perhaps it's even more important if we're dealing with it, because I mean, usually there isn't obviously much potential for a factual disagreement between criminal litigants as to whether or not somebody died as a result of careless driving. But what does very frequently trouble the magistrate's court in cases like this is whether injuries sustained by a particular person amounted to grievous bodily harm. And although this case did not present the quandary, at least as far as I'm aware, one can easily imagine a situation in which multiple persons are injured as a result of a single act of careless driving. And though it is clear that person A was caused injuries which could only reasonably be described as grievous bodily harm, person B may have been injured in a way which is subject to debate, and the court is going to have to resolve by application of the ordinary principles whether or not it is satisfied to the criminal standard that the injuries to person B amounted to grievous bodily harm or merely only bodily harm. And that dispute is not at all an uncommon one in our courts. There are cases from the very same puny judge that heard this appeal dealing with that very issue in other cases. So in my respectful submission, that is another compelling practical reason why it is perfectly appropriate for there to be separate counts in these sorts of situations.
Oh, sorry, if going back to your example, one person is seriously injured, clearly within the grievous bodily harm category.
Mm-hmm.
Person B has a very minor injury, a scratch, clearly not in the grievous bodily harm category. So what do you say is the right course to follow there?
Well, in that circumstance, my lord, if it was clear that there was only one person injured to the level of grievous bodily harm, then I would anticipate that there would be a single count of causing grievous bodily harm to that person.
Because there's no point in having a second count of careless driving simpliciter.
Right, because it would add nothing. There, I have to concede that the actus reus of the careless driving simpliciter, as your lordship puts it, is wholly subsumed in the count of causing grievous bodily harm by careless driving. But that is not so in my respectful submission when more than one person is caused injury amounting to grievous bodily harm. And the hypothetical that your lordship has put to me is obviously slightly different from my hypothetical. I was presupposing that the question in relation to person B was more finely balanced, that there was a genuine...
And that's why I went to my example where it's not an issue which has to be decided by the magistrate. There's no question about it. So
yes, and as your lordship will see from the table.
If the position is that there are 2 people injured, one is grievous bodily harm, and the other isn't grievous bodily harm.
Yes.
In a sense, it doesn't matter for the prosecution's purposes, because the defendant, if charged on a single count, will still have been found guilty of causing grievous bodily harm, because that will be the case in relation to one person.
Yes.
A better approach might be that if the position is that he may have caused grievous bodily harm to 2 persons or one, it would be desirable, well, certainly in a case in front of the jury, to have two separate counts in order that you could know for sentencing purposes whether he had grievously harmed two or only one.
Yes.
But even more so, assume an accident in which one person is caused grievous bodily harm by careless driving and the other is killed.
Yes.
You would want to be able to distinguish between the two and to have them separately tried, because they're two completely, well, in a sense, completely different crimes.
Well, when your lordship says separately tried, I assume you mean separately, separate counts on
Separate, I mean,
the course of one trial.
Yeah.
Yes, I agree, my lord. That is the point in my respectful submission. So there are good practical reasons why the approach that is the consistent approach of the prosecuting authorities in this jurisdiction in cases of this type is correct to charge separate counts in this way. And I mean, obviously, the other point I suppose that I could add to what your lordship has said is that in fact, what I wanted to pick up on, I think, was that your lordship had used the phrase particularly in a case tried by a jury. And I do take the point that obviously a magistrate is more able to articulate than a jury in a hypothetical situation that he's confronted with one count of causing GBH to two persons. He has a better mechanism by which to say, oh, well, person A was, I am sure, caused GBH, but person B was not. And I think that's a point that's touched upon in the Tovey decision, which the court asked us to look at overnight. But in my respectful submission, it can't be as a general principle that these sorts of cases must have separate counts in the Supreme Court when they're tried on indictment, and must have combined counts when they're tried summarily in the magistrate's court. Because even if I were prepared to concede, as I think I might just about, that some of the cases that we have before us suggest that in this case, there could have, as a matter of law, been a single count of causing grievous bodily harm to both these persons, which I do have to say that I have some difficulty with for reasons I will come on to in a moment. But even if they can be read to say that that is a possibility, what, in my respectful submission, none of the case law says is that what the Crown did was wrong. There isn't any decision that I have found or that is come to light as a result of the respondents' researches or indeed the courts that says it was erroneous or duplicitous for the Crown to have charged two separate counts in this case. And that is exactly what the Supreme Court judge said. Paragraph 21.
Come back to my example. If you have one act of careless driving that kills one person and causes grievous bodily harm to the other, it would be almost impossible to proceed by a single count.
Yeah.
What is the count? If the count is causing death by careless, is causing a grievous bodily harm by careless driving, you completely forget about the murder. If the count is murder of one individual, the grievous bodily harm to another is irrelevant.
I don't think I followed your lordship's reference to murder.
I mean, I think we're talking about either causing death by careless driving or causing grievous bodily harm by careless driving.
That's what I meant, sorry.
Yes. It would, I mean, obviously, it would be deeply impractical to have one count that alleged causing death of one person and grievous bodily harm of another person by careless driving in a single count. I mean, it would present all manner of practical difficulties.
It's unworkable.
Yes, I respectfully agree. And the other problem that I have with the argument of the learned Supreme Court judge, as encapsulated particularly in paragraph 21 of her judgment, page 286 of the record, is that in fact, if we had done as she contends or found we ought to have in this case, I respectfully submit that it would have in fact offended the very rule that she has mentioned, the rule against duplicity, because if we had alleged causing grievous bodily harm to two persons in one count, that would have rendered that count duplicitous, because we would be alleging in a single count two offences, and that, in my respectful submission, is simply not permissible. It offends section 480 of the Criminal Code, and this is referenced at paragraph 18 of my first set of submissions, although I suspect it's not necessary for your lordships and your ladyship to turn to them now. And for the avoidance of doubt, although I know that in England and Wales, the criminal procedure rules have now been modified to permit the capture of a course of conduct in a single count in an indictment, and that is Criminal Procedure Rules 10.23 in England. There is no corresponding provision in the law.
Section 480 say?
Section 480 says, forgive me, my lord, I shall read it to you momentarily.
Did you say that was in your first set of submissions?
It's referenced in my first set of submissions of
Yes,
paragraph
yes.
18, my lord, but actually I don't think that
It's
I
not
have
set out.
quoted section 480, so I will
Right.
read it to your lordships now. So section 480 deals with the joinder of charges in indictments. It's based on former English legislation, which I think was the Indictments Act 1915. But there is a proviso to subsection 1 of that section, which says, provided that no one count of an indictment shall charge an accused person with having committed two or more separate offences. So, I mean, obviously, in order to engage that proviso, you have to accept my argument that we are dealing here with two separate offences. But if I'm right about that, then clearly, in my respectful submission, it is duplicitous to have done what the learned judge seems to think we ought to have done, namely naming both complainants who were injured in this case in a single count.
Well, I don't understand that, because if you read section 37A as the singular including the plural, why can't there be a count which includes somebody who's caused the death, for example, of a number of people by careless driving, on the basis that another person could be another persons in the plural?
That's not a point that I have candidly thought about, to be honest, my lady, but I whilst I accept that that's a general rule of statutory interpretation, I don't accept that it's proper to apply it here.
Why not?
And in any event, as I say,
why isn't it appropriate here? Say you've got somebody who in a car swerves and causes a coach to fall off a cliff and 30 people are killed. I mean, wouldn't happen in Bermuda perhaps, but might happen somewhere else.
Yes. Well, my lady, the main reason that I respectfully contend that it is not appropriate in those circumstances to charge the grievous bodily harm to 30 persons in a single count is the practical reason that I have already advanced. And so I won't repeat that unnecessarily.
Why shouldn't it include a number of persons as a matter of interpretation of section 37A?
Well,
That's what I don't understand as a
Melanie,
matter of construction of the section.
I just don't see how that can be a practical way of proceeding in a criminal case where there may very well, particularly in a case that's involving injury to 30 persons, be a very real issue as to whether each and every one of those persons was caused grievous bodily harm.
Yeah, but my hypothesis was that 30 people were killed.
Oh, I'm sorry, all 30 persons were
It doesn't
we're
matter.
we're now in the coach over the cliff scenario, so there's no question of degree. They're all dead.
Yes. Well, respectfully, in those circumstances, I mean, it may well be different in England by virtue of the criminal
Well,
procedure.
let's assume we can do it on the North Shore, and we can indeed go over a cliff, and that 30 people die. So this takes place in Bermuda.
Right. Well, I do not believe that it would be appropriate to reflect that in a single count. I believe that it would be appropriate to charge 30 counts in order to reflect that 30 deaths were caused. And in my respectful submission, even if I'm wrong about that, the issue here is not whether, or ought in my respectful submission to be, not whether the Crown could have charged a single count in these circumstances, but whether the Crown did anything wrong in charging two separate counts, because that is what the Supreme Court found. The Supreme Court found that we charged two counts erroneously,
yes,
and duplicitously. And in my respectful submission, there is nothing in any of the case law that supports the contention that we were not entitled to charge this matter as we did.
Yes, and be it assumed for the moment, just thinking aloud, that the singular includes the plural. That means you can use either the singular or the plural. So you could have a count which said that you caused the death of 7 people, or you could have 7 counts that said you caused the death of 1 person in each of them.
Yeah, I suppose that the difficulty I have with a count that says you caused the death of 7 persons is that I think that each death is a separate actus reus, and that therefore, in fact, in order to respect the proviso to section 480 subsection 1 ought in those circumstances to charge separate counts. But even if the court is not in agreement with me on that, and I have to recognize that reading it to include the plural is not a point that I must confess had occurred to me, but it's one I guess I would have to think about a little bit more in the criminal context. But my fundamental submission, as I have already said, is that even if we could have done it differently, it is wrong to say that we were not entitled to do it the way that we did.
If the singular includes the plural, and that's the way getting around it, I think a number of English authorities fail to have noticed this. We'll get to them in a moment.
I'm afraid I'm not sure I followed the last thing your lordship said. I'm sorry.
If when it says causing the offence is, when it says if a person causes death by careless driving, that can also mean if more than one person causes death by careless driving. If that's a potential analysis, it seems to me that that potentiality is something that has not been considered by any of the English cases that we're about to look at.
Yes, I think that's right, my lord. And I mean, it just seems that, you know, it's in the ordinary course of criminal litigation, it's incumbent upon the Crown to prove each element of the offence.
Yeah.
And even though one can construct a hypothetical in which all 30 persons have died, and in those circumstances, the various practical challenges that we have discussed thus far don't arise, In my respectful submission, that does not alter the fact that there will, in the majority of cases, be sound practical reasons why a single count is not commodious. And the better practice for that reason, my respectful submission, and the practice ought, I would suggest, to be consistent and not vary according to the particular facts of the particular case, is that there should be a separate count for each death and each GBH, or each person that is caused GBH by the same act of careless driving. And that is an approach which, even if it's not the only justifiable approach on the authorities, is certainly one which is perfectly proper on those authorities, in my respectful submission. And so
so you say it's wrong for the judge to say that the prosecution was wrong to follow that route?
Exactly so, Lord, yes. And of course, and I don't wish to be uncharitable, but wrong particularly to say it without that being the substance of the argument that was had before her, because that wasn't Mr. Daniels' argument, at least so far as I have understood it. He was really complaining more that the total sentence exceeded the maximum.
There's no question, but that you're right on that, because Mr. Daniels hasn't taken the point to this time.
Indeed. So, and of course, you know, had it been flagged that that was the court, the Supreme Court's view, then that's something that the Crown could have pushed back on, and we may not have succeeded in persuading her that she was wrong. But it was, in my respectful submission, not correct to criticize the Crown in the terms that she did in paragraph 21 of her judgment, when that wasn't the substance of the argument that she had heard. So, my lords, the court has before it now a number of authorities in the joint authorities bundle.
Yeah.
And that includes an extract from Blackstone's. Blackstone's did appear to confront this issue a little more directly, in my respectful submission, than Archbold. So I haven't included an extract from Archbold because I couldn't find one that directly addressed this issue, which is perhaps surprising, but there it is. But your lordships will see, and your ladyship will see that in the extract that I have provided from Blackstone's, a paragraph D1153, which is page 1681 of the book.
D1153.
Yes, and for completeness, this is Blackstone's 2019, which is the most recent edition to which I had access. But there is a short section on instances of the application of the rule against duplicity in cases where there are several victims. There it's stated that old cases provide examples of a single count naming more than one person as the victim of the offence. The example that's given there is the case of Giddens, which I have supplied to the court.
Right.
Modern practice, however, is in general to have a separate count per victim, and there the case is Mansfield. Now, having actually looked at Mansfield, it doesn't seem to me that Mansfield squarely addresses the point. I mean, it is an instance.
I mean, just going to Giddens. Giddens was a case where there were an assault on two persons, so it's a little hard to say that that would have been one actus reus.
Yes, it's a case which I wouldn't cite with a great deal of enthusiasm, my lord. It's quite old. And I've really only cited it because it's...
Because Blackstone makes reference to it, but...
Yes. I take your lordship's point. I think it is a little different from this scenario. In any event, I think...
Well, just a moment. In Giddens, Mr. Giddens robs two people. He stole 2 shillings from one of them and 1 shilling and a hat from the other one.
Yes.
And the question was whether or not the count was, whether that was duplicitous. And the judge, in an admirably concise judgment, says no, that it was all one act and an entire transaction. So the count was not duplicitous. but there were undoubtedly two attacks, one on A and the other on B.
Yeah.
Yes.
And
Yes,
the fact-
it's impossible to conceive of the force that was applied to both complainants being precisely the same action on the part.
Absolutely. So it's quite, I think it may be quite possible that you can have a count that is not duplicitous because it's all one transaction or one activity, but you could in fact have two separate counts for the two separate parts of that same activity.
Yes.
Sorry, yes meaning yes, or yes meaning not really?
I think I agree with you, as long as I've understood your lordship correctly. There may be circumstances in which those separate counts might be the better course. A single count would not be duplicitous.
Yeah.
But I mean, I suppose another distinguishing factor here, of course, is that robbery is quintessentially a conduct crime. Causing GBH by careless driving is concerned not only with conduct but also with consequences, which is material to what I say the ambit of the actus reus is, but I won't repeat that submission.
No.
Then the case of Mansfield is cited as an example where M was charged inter alia with 7 counts of murder, a different victim being named in each count, even though all 7 deaths resulted from a single fire allegedly started by M. And your lordships and your ladyship have the judgment in Mansfield in the joint bundle of authorities. Again, I've produced it for you because it is the case that's mentioned in this part of the commentary in black.
I mean, just having had a quick look at Mansfield, I mean, what Blackstone says is that M was charged with 7 counts of murder, a different victim being named in each count, even though all 7 deaths resulted from a single fire allegedly started by M. Looking at the facts of Mansfield, he seems to have started any number of different fires.
But I think that there were 7 deaths resulting from one of those fires, my lord.
There was only one of the fires at one of the hotels caused deaths.
Of course,
yeah, I think that's right, my lord. I mean, again, I don't know that this is a particularly helpful authority because notwithstanding the proposition for which Blackstone cites it, it doesn't seem to me that the correctness of the 7 separate counts is directly confronted by the court in Mansfield, because that doesn't really seem to be the issue that the court was required to decide.
The court didn't think it necessary to address its mind to this question because nobody raised the point.
Right.
But if Justice Subel Williams is right, it was wrongly decided.
Yes, exactly so.
So on the face of matters, Mansfield would, which is after all an English Court of Appeal decision, would tend to suggest that the right course is to have 7 counts.
Yes, and respectfully, the annals of the Court of Appeal Criminal Division are going to be replete with cases where precisely the same was done. It's maybe that now that the criminal procedure rules have provided for conduct counts, that practice has altered a little. But in my respectful submission, it is not at all uncommon for multiple victim cases to be indicted in precisely the way that they were clearly in Mansfield.
Right.
So
Are you going on further in D1153?
Well, I was going to just briefly read out what's stated at the top of the next page, because we then go into Shillingford, where the Court of Appeal said that it was unnecessary to have 2 separate counts where it was alleged that the appellant had administered a drug to enable both himself and another to have unlawful sexual intercourse with the victim. According to Salmon, the essence of this offence consists in administering the drug, and accordingly, in this particular case, there was only one offence under the section in the view of this count, if there is only one administration, there is only one offence, whether the administration was for the purposes of enabling one man or half a dozen men to have intercourse with the woman in question. And in my respectful submission, that highlights a difference in the nature of the actus reus in that case, from the nature of the actus reus that we have in this case, where we are concerned with the consequences of a particular piece of conduct rather than the intention with which that conduct was engaged in. So there, as the Court of Appeal said, there was a single administration. It may have been perpetrated with the intention that that multiple further acts were going to be committed, but there was a single administration. Here, there were multiple consequences, physical consequences to separate persons of the single act of careless driving. And in my respectful submission, that is a material difference. Then we have the case of Jameson and Priddle, where an information for taking and killing 2 red deers was held not to be bad for duplicity because the deer were shot within seconds of each other. In this case, however, there certainly could not have been an objection to 2 informations. And so, in my respectful submission, we come back to what I was saying earlier, which is that even if the court considers that on the authorities, a single count could have been even if a single count could not have been challenged on the grounds of duplicity, that does not mean that 2 separate counts were wrong in law. The court has asked us to look at the decision of the Court of Appeal Criminal Division of England and Wales in the case of Tovey and Smith, and I have done so. The particular section to which we were invited to have regard was that starting at paragraph 20 of the judgment. I did put a PDF version of the judgment in the cloud, just so that we're all referring to the same version of the document.
Just hold on a second. Are we looking at this in the cloud, or where are we finding it?
It is in the cloud, my lord, but it may well be, since the court drew this authority to our attention, that you have your own copies elsewhere. I don't know.
We have had other things going on. Let me try and find.
What's the name of the case again?
Tovey and Smith, my lady.
Thank you.
So where do we, Mr.
It's in the
Quayle,
cloud. It's in the joint authorities in the cloud.
oh, that's not what I want. Yes.
So paragraph 20 of that judgment, my lords, my lady, references another case of Barton, wherein it's observed that defendant appealed by way of case stated against the stipendiary magistrate's decision that an information alleging theft of £1,338.23 over a period of years did not offend against the rule that an information should only allege a single offence. The evidence in support of the charge indicated that there had been 94 takings from the cash register covered by debit entries. Divisional court reviewing the authorities on continuous offence. Despite the fact that the individual appropriations were each capable of being separately identified, Divisional Court concluded that it was permissible to charge the whole course of conduct as a continuous offence because the defendant had no specific explanation for individual takings and put forward the same defence for all. So in my respectful submission, again, here we're dealing with a situation where the courts found that separate counts could have been lawful, but that there was no objection to the single count. But in my respectful submission, when we're dealing with theft from a single individual, I don't know whether that was a business or a person, but when there clearly has been one loser in these 94 separate takings, we're in very different territory from this situation in which two separate persons were each caused very significant injuries.
Well, even in the case where there was 94 takings from the same cash register, if you go further on in 20, there's a citation from what Lord Justice Kennedy said. Here the prosecution's case was, we understand, set out in a schedule with dates and amount indicating what was involved. Undoubtedly, each line in the schedule could have been charged as a separate offence. But had they been so charged, on average, the amount involved would have been about £15. So the court was proceeding upon the basis that it was legitimate to charge them as a single count, but that they could also, all 94 of them, have been charged as separate counts.
Yes, albeit that it is then stated at paragraph 28, my lord, as we have seen, Kennedy LG pointed out that to have 94 separate informations in his case would have been oppressive.
Yeah.
Now, in my respectful submission, that's not a principle that is engaged here. It is not, in my respectful submission, reasonable to suggest, nor has it been contended, that having two separate counts was in any way oppressive. So, in my respectful submission, again, there is nothing in this case to support the contention that the way in which the Crown proceeded in the Magistrates' Court was wrong.
And if you go back to paragraph 26, Lord Justice Kennedy also prayed in aid the comments of Professor John Smith about a particular case. In that case, Professor John Smith said, if a thief walks around a house putting a series of articles into his swag bag, it is clear that he commits a separate theft with each appropriation. He could be charged with theft of any one of the articles appropriated, but it makes sense and involves no unfairness to the offender if he's charged with a single theft of all the articles taken on that occasion.
Yes.
It's regarded as a single activity, legitimate to charge one activity in a single information, even though it may involve more than one act. So there's again an example of a situation whereby you can have separate offences, and you could charge separate offences, but you could also aggregate them, if they were a common activity, into one count.
But that's different from here, isn't it? Where you've got one act, which is driving carelessly.
Well, that's
my lady, I accept.
But the offence is not simply acting carelessly; it's acting carelessly and causing something. The actors, well, it seems to me that
Driving carelessly.
Well, it's driving carelessly and causing either, well, in this case, grievous bodily harm. The actus reus is not just driving carelessly.
That's my position, my lord. And in fact, I mean, may not be the strongest point, but it's interesting that the legislature actually puts the consequence first in section 37A. It's anyone who causes grievous bodily harm by driving carelessly. So
instead of saying who drives carelessly and causes grievous bodily harm by so doing.
Yes. And that's consistent, in my respectful submission, with the scheme of this legislation. And this is where I think we do need to have another look, if we might, at my table in paragraph 4 of the second set of submissions. Because, and that's the something which I know my Lord President doesn't have, but perhaps Mr.
I know
Are you looking to have it brought back up?
No,
It's on the cloud. They're on the cloud.
Yeah, but not
for me. I know what the table. I know what the facts are in the table.
Right. So the point I want to make now is that we have a scheme of the legislation where the maximum penalty, even for a first offence, increases significantly depending upon the consequences of the careless driving. So An offence of simple careless driving is punishable by a maximum of a $1,000 fine. It's not even imprisonable. A first offence of causing grievous bodily harm by careless driving is punishable by a maximum of 3 years imprisonment and a $3,000 fine. And lastly, a first offence of causing death by careless driving is not triable summarily, only triable on indictment, and it's punishable by a maximum penalty of 8 years imprisonment. So in my respectful submission, as I have endeavoured to argue in paragraph 5 of this second set of written submissions, the legislature has clearly made the judgment that in order to ensure that persons are properly encouraged to drive carefully on Bermuda's roads, there are increasingly severe penalties for those who, in the course of failing to do so, cause serious harm to others. The more serious the harm that they cause, the greater the penalty they are liable to. If they cause a death, they can get up to 8 years imprisonment. If they don't cause any injury to anyone, or at least none that amounts to grievous bodily harm, they can't even be imprisoned. They will only get a fine and can only be dealt with in the magistrate's court. And in my respectful submission, it's against that background that it is entirely consistent with the statutory scheme to say that an individual who causes grievous bodily harm to more than one person is properly liable to a greater penalty than one who causes grievous bodily harm to only a single person. And so in my respectful submission, as a matter of principle, consistent with the legislation, there was no reason why the learned magistrate ought not properly have been entitled to impose fines separately for both of these offences. And further, I say that there was no reason why the total amount that was required by the defendant to be paid exceeded the fine which could have been imposed for a single offence. Now, I say that for a couple of reasons. One is that the fine of $3,000 for a single offence was not the maximum penalty to which an individual convicted of a single offence would have been liable, because, as we know,
It was only the case if that was done in magistrate's court.
No, that's not the point that I'm making at the moment, my lord, but it is a point that I do rely upon and I will come back to. So thank you for that. But what I'm saying at the moment is that the maximum penalty to which the individual is liable in the magistrate's court on conviction of a single offence is not a $3,000 fine, it's 3 years imprisonment and a $3,000 fine. And in fact, as I have pointed out, and I believe it was actually my first set of written submissions, the magistrate's court has the power to send a case upon conviction to the Supreme Court for sentence. That's section 43 of the Criminal Jurisdiction and Procedure Act 2015, and I addressed this at paragraph 31 of my first set of submissions. By operation of section 56C3 of the Criminal Code, in circumstances where the maximum period of imprisonment available to the Supreme Court is 4 years, as set out in the table in paragraph 4, the maximum fine that would have been available to that court, either had the matter been tried there or had it been sent there following conviction, for a first offence and a single offence, would have been $7,500. So to the extent that my learned friend's complaint about the fine, the total fine that was imposed here, rests on the contention that it exceeded the maximum penalty, there are two problems in my respectful submission. First, that it didn't exceed the maximum penalty even available to the magistrate, because the magistrate had a power of imprisonment. that was not used. And further, that in fact, even the maximum fine available on conviction for this offence, even when the trial has been held in the magistrate's court, is not $3,000, but $7,500, because the court has the power to send the matter to the Supreme Court for sentence. Now, of course, it's right that the Crown did not ask that the matter be sent to the Supreme Court for sentence. But in my respectful submission, when the magistrate has before him two counts, on either of which he could impose a fine of up to $3,000, is it seriously necessary for him to send the case to the Supreme Court in order for a fine of $3,001 to be imposed lawfully? No, in my respectful submission, that would be an absurd position. If he's got two counts before him, upon which he has the power to impose a $3,000 fine, there is no reason in principle why he should not be perfectly entitled, in my respectful submission, to impose two fines that are both separately below that limit.
I think that follows, Mr. Richards. If he's got the two counts before him and the two counts are properly before him, then he can clearly impose a fine of $2,500 in respect of each.
Well, I agree, my lord, and it may well be that I don't need to say very much more. But that certainly is my argument, and to the extent that it's suggested that it was wrong to award a cumulative fine in excess of what the magistrate could have done on conviction for a single offence, in my respectful submission, that submission is not correct.
Yeah.
I seem to have come to a rather more sudden stop than I myself was expecting, but it may well be that I did.
This is not something to apologise for.
You don't mind that, Mr. Richards?
No.
I hope I haven't neglected to mention anything I should, but would your lordships just forgive me one moment to just compose my thoughts? I won't take long. No, I don't have anything further for your lordships and your ladyship at this time. Thank you.
Thank you. Yes, Mr. Daniels.
Good evening, my lords and my lady. Now,
Yes.
having heard those brief remarks, I do not want to exhaust much more of your time, but I think there is one area that I can properly piggyback off of for your consideration, and that would be this. As I've tried to articulate, I agree with the arguments that have been put forward quite properly and well delivered and advocated on behalf of the Crown. I also appreciate the law.
When you say you agree with the arguments, you're saying both in respect of the period of disqualification and in respect of the fine?
So with respect, the disqualification issue is a non-starter, respectfully. I think we're in all fours on that point.
Right.
The issue of the fine is I never challenged the narrative that two counts could be brought based on the injuries to two different people. Notwithstanding, I maintain that there is one act of careless driving. I appreciate the argument that my learned friend has advanced in terms of the elements that have to be established. But I also accept the arguments that are set out in the Tovey case, that the way that this could have been addressed is through one charge, or it could have been done through two different charges. The question ultimately comes down to the effect as it relates to the convicted person and the impact. And so my learned friend had suggested that it was open, having put on an information sheet two specific charges. The magistrate was then entitled to sentence on behalf of those two specific charges. And to that extent, I agree. And then the question is that if the learned magistrate felt that it was necessary that the sentencing powers available to him or her, in this case him, in the magistrate's court were insufficient for the facts of the case, the matter could effectively have been sent up. Irrespective of the Crown not making a request for it to be sent up, the learned magistrate did not consider it was necessary to in fact send up. And so he approached on the basis of imposing the $2,500 fine in respect of both of the charges. And I appreciate the argument that my learned friend makes that the maximum penalty is a period of imprisonment together with a fine. But historically, my understanding is that in this jurisdiction, and I don't think that by any construction, this has been considered the most significant or horrendous case that's come before the bar, but that the facts in this case did not warrant clearly that to be sent up. But having actually gone before the matter of appeal, the Supreme Court, my learned friend is correct, I did make the issue of the fine an element of my complaint, generally of the totality of the sentence. And I had indicated that the maximum fine having been imposed with respect, i.e. $3,000 as a total sentence would have been fair. So I do accept what my learned friend said in terms of I didn't raise the point because I actually did. My primary point was focused on the disqualification point, which we've now moved past. So the issue I would just simply invite your lordships and ladyship to consider is that having gone before the Supreme Court still exercised its discretion based on the facts and the arguments presented to it, that $3,000 was an applicable and fair total amount, the construction of which I appreciate is where the argument.
But the judge reached that figure of $3,000 operating on the basis that she was constrained by the fact that since it was one actus reus, it should be treated as one count.
Yes, but I guess what I'm inviting this court to also.
If the judge was wrong on that, and it was indeed properly charged as two counts, then the judge would have left the 2,500 times two in place.
Yes, arguably so. Or the judge could have been, and this is where it's, again, a matter of totality that I had presented to the court, that effectively 2,500 in respect of both of the charges was manifestly harsh and excessive in all the circumstances. And I don't think it's a matter that quite properly that the Crown should look at creating multiple charges. In this case, I agree with my learned friend that there's nothing oppressive about the two counts. But in the examples that were given, if there were 7 charges or 10 charges or 94 charges, as we saw in the, not Tovey, but the other case that was cited.
The theft case.
Yes, in that regard, certainly it wouldn't be an exercise of trying to seek the maximum amount of fines by virtue of the number of counts that are put forward. And at all material times, when it comes to looking at the issue of fines is something that the totality principle would fall under the totality principle in my respectful submission when assessing the individual accused, their ability to pay and so forth. But that's pretty much as far as I can take the argument. I agree with the substantive arguments that the Crown was not wrong insofar as bringing 2 specific charges. And then the question ultimately that the learned sentencing magistrate had before him was to consider what is an appropriate fine in relation to those charges.
Well, then you get into an exercise of discretion and probably difficult for us to interfere with.
Which I accept. But for the purposes of the more academic argument that's being sought for future guiding cases, as I said, I didn't want to appear as if I'm putting up a significant resistance. It's a matter of principle that I accepted at the time of trial, and I accepted when we appeared before the appeal. So it was a nuance that was presented during the course of the appeal. And I'm not trying to be cheeky, not with any particular impacts from my clients.
Right. Well, thank you very much.
Thank you, my lord.
I don't think there's anything you need to add, is there?
No, there is just one small point that I did mean to mention earlier, which unfortunately I did not remember just before I finished. I hope my learned friend won't mind me very briefly touching on it. And the reason I mention it is because it just occurs to me that when your lordships and your ladyship are deliberating on the matter, you may well go back through the transcript of the Supreme Court proceedings. If you do so, I'm just anxious to dispel what I think was a period at which a friend who appeared in the Supreme Court and the court were somewhat at cross purposes. So if your lordships and your ladyship would be kind enough to look at page 271 of the record of appeal.
The cloud is preventing me from downloading it, Mr. Richards, I'm sorry.
Well, I don't want to detain your lordships and your ladyship. No, I think we have it now.
I seem
Yes.
to get into the cloud the first time, and then it doesn't like me going back and having a second look.
No.
It's hopeless, isn't it?
Yeah.
Mm.
So the court is speaking at
Just
the top
give
of
me
the
the reference, though. Which page of the transcript, Mr. Richards?
It's page 62 of the transcript, page 271 of the record of appeal. Mr. Coelho has, I think, tried to share the screen, although it seems as though perhaps your lordship's not seeing it.
Not yet, I'm not. Let me just get out of this.
It takes 2 minutes to download the record for the second time.
I do now have it, so that's 271 of the record. I do now have it, thanks to Mr. Coelho.
So starting at the top of the page, her ladyship says in terms of how to treat one accident for the purpose of sentencing under the TOPA. So let me just for a moment go back to the point that troubles me. So you say, Mr. Rogers, that's my colleague who appeared below,
Yep.
that the information should be treated as someone who is serving as a first offender or a second offender because there are two different charges. Mr. Rogers says, my lady, I think that we would have to accept that it would be a first offender. Given that it is arising from one accident, her ladyship says. She then proceeds to refer to part of the legislation. And then if we could go over the page, because I really don't want to have to read all of it out to your lordships now. There is then a colloquy halfway down the next page, but he's treated it as two offences, says the court. Mr. Rogers says, yes, my lady. The court says, but you've just accepted that he's a first offender. Mr. Rogers, yes. Court, I mean, can those two positions cohabit? And Mr. Rogers says that he believes they can. And here in my respectful submission, I believe that there was some confusion because obviously the Crown contends that the appropriate maximums for the purposes of approaching both of these counts was the maximums that are set in the legislation for a first offender, because one only becomes a second offender if you have previously been convicted of an offence and then commit a further such offence within a period of 2 years, in fact. So it's actually quite difficult to get into the second and particularly the third offender category. The Crown was not, for the avoidance of doubt, never has suggested that the court ought to approach either of these counts as being one that was governed by the second offender principles. My learned friend was properly, in my respectful submission, recognizing that the maximums for both counts would be the maximums that were set for a first offender, because even though we say there can properly be two offences here, both of them occurred simultaneously, and so they were both first offences. So I just wanted to highlight that area of confusion that I think arose in the court below, in case when your lordships and your ladyships were reviewing the transcript, it caused any concern. But otherwise, I have nothing further to submit unless the court has any questions.
Well, I understand that, and this probably doesn't arise, but the position is it that you can only become a first offender if you have been convicted of a first offence, although you did in fact offend when you first did so?
You can only become a second offender if you commit a further offence within 2 years of being convicted of the first offence.
Right.
And for that reason,
that's what the statute says, does it?
Yes. So for that reason, becoming a third offender is really quite difficult, one would hope, but not perhaps impossible. If your lordships want the statutory reference for that, I will get it quickly. Right, so my lords, my lady, it's section 2, subsection 3 of the TOPA,
Okay.
which is in the cloud, but it may not I don't know whether your lordship actually want to look at it now.
No. Thank you. Very good. Well, we're most grateful to counsel for their tightly expressed and shortly expressed submissions. And we will give judgment in due course.
Thank you very much, my lords and ladies.
Thank you very much indeed.
Yes.
All right, that concludes the appeal, everyone. Thank you.